Sean Wiggins for the state of Florida.
Jennifer Garcia for the state of Florida.
Catherine Conlon, along with Andrew Parnell, we represent Danielle Redlick, who's present in the courtroom.
Good morning, everyone. We have 8 jurors. Ms. Conlon, you said you had something. Yes.
Since the state has not started their rebuttal case, we're requesting that the court allow us to reopen the case and call Detective Ware to present to the jury what she proffered yesterday. May I approach with case law? The first page is 90.609, which says that any party, including the party calling the witness, may attack the credibility of a witness by, and subsection 5 says proof by other witnesses that material facts are not as testified to by the witness being impeached. School. Dad said to Jaden, "You better have a good lie as to where you have been." This statement shows that at a minimum, Dad was angry. He was upset with Mom by making that sarcastic comment. It shows that her credibility is at issue, and that's the reason why we would ask that Detective Ware be allowed to impeach Jaden's testimony where she denied ever hearing that, because it's clear that she actually, well, Detective Ware said that Jaden made that statement to her. As far as the Emmy's testimony that she never told law enforcement that Michael Redlick bled out within 5 to 6 minutes, that was contradicted by Detective Ware, because the how long it took Michael Redlick to die is certainly a material issue in this case. The longer it took, and she, as in the medical examiner, testified that it could take hours, it's material to impeach that at one point she actually told Detective Ware that Michael Redlick bled out within 5 to 6 minutes. Dr. Zadovich, she denied on cross-examination that she ever said that Michael Redlick died within 5 to 6 minutes. And whether or not Michael Redlick died either quickly or slowly is a material issue in this case. For the court, I have provided Butler v. State. In this case, the defendant in the case testified at trial that the victim had invited him over. And furthermore, that he went there to pick up his clothes. The court allowed an officer who was a supervising officer of the 2 officers who were on scene, who had looked through the house to see if there were clothes in the house that belonged to the defendant. And these 2 officers had told the supervising officer who testified at trial that, no, we didn't find any clothes. So that officer, so we have hearsay, that officer was allowed to actually impeach the defendant who had stated, "I was invited over." I've also provided the last case, which is Spindler v. Brito de Forge, 762 Southern 2nd, 963, that the shifting sands of a trial may cause a judge to rethink an earlier evidentiary ruling based on a matured understanding of the case. For those reasons, we would ask that under 90.608, subsection 5, that we be allowed to have Detective Ware testify as to what she proffered yesterday. The state, oh, sorry. So the argument yesterday was that the foundation was not laid, and that was what the Pierce case was about. We were not proceeding under subsection 1. Under subsection 1, which is introducing statements of the witness which are inconsistent with the witness's present testimony, that would have required the foundation. That would be if let's say Jaden Redlick had given a deposition and I was trying to impeach Jaden Redlick with her deposition. And at that point, I would go through the impeachment process, as I think the court mentioned yesterday. That is not what we were trying, that was not how we were impeaching yesterday. How we were impeaching yesterday was we already had the statement that Jaden made. Now we're bringing in Detective Ware to contradict Jaden's statement as well as the medical examiner's statement at trial.
So there are two statements, basically. One is Jaden's testimony regarding you better have a good lie as to where you've been. And then the second one is Dr. Zagovich stating that it took hours for the victim to die instead of the 5 to 6 minutes for the victim to die, which is what she originally told Detective Ware. So there are two
Yes, it's
issues? Okay.
those two issues, and I just want to clarify for Dr. Zadovich is that what she testified to, what I asked her was, did you tell anybody that Michael Redlick died within 5 to 6 minutes? Her response was no. So Detective Ware, I would expect, well, that was her proffer, that she had been told by Dr. Z that she as in Dr. Z said that Michael Redlick would have bled to death within 5 to 6 minutes. And these are both material issues in this case.
Okay. What I wanted to know, as it relates to Dr. Zagovich's statement, whether you said whether he died quickly or slowly is material. Can you just explain how the timing is material for your presentation?
So the reason why it's material is because the testimony from Ms. Redlick was that after the stab, she ran into the bathroom and that she hid in the bathroom for a while. So if Michael Redlick was dead within 5 to 6 minutes, it brings more credibility that when she came out, he was already dead, if that makes sense. Now, if the ME also said it could take hours for him to have passed away. So as Ms. Redlick testified, after the stab, she went into the bathroom. And if the ME's statement or testimony is correct, then when Ms. Redlick came out, presumably Michael Redlick would have still been alive. So we're attacking how long it took, the credibility of Dr. Z's, I'm sorry, I'm using Dr. Z because it's hard to say Dr. Zadovich. So the timing of it is material in this case.
Okay. What about the statement from the victim where Jaden is saying, my dad said, you better have a good lie as to where you've been? How is that material?
So the way Jaden, her testimony, she testified that on January 10th, which was the Thursday, that her dad was very angry. He was visibly upset. However, it changed. On January 11th, her dad was apologetic to her, was loving, he was calm, and the way she viewed the interactions between how Michael Redlick was acting on that day with Danielle was that things were calm, he was back to his old self, he was very nice. This statement undercuts that presentation or perception of how dad was acting. Because if he's making a statement such as, you better have a good lie as to where you've been, it shows that he was still angry from the previous day and that it continued.
Yes, None of what Ms. Conlon has said has actually addressed the issue that caused the court to deny the request for impeachment. Ms. Conlon has just come before you and cited to 9608, and she said that we're going under subsection 5. Subsection 5 is introducing material facts that are not what the witness testified to. So, for example, the witness says the light was red, and you bring in a witness to show that the light was green, or, you know, the car was speeding versus the car was not speeding. You introduce material facts to impeach another witness's testimony. Ms. Conlon is still proceeding under subsection 1. She still wants to introduce statements via another witness for the purposes of impeaching the other two witnesses, Dr. Zadovich and Jaden's credibility. So we're not in any way, shape, or form out of section 1, which, to the extent that we're not out of section 1 at all. The fact that she's trying to do it through an extrinsic piece of evidence, that is another witness testimony, still requires that she had done a proper impeachment predicate on the front end. She hasn't fixed that in any way, shape, or form. She can't fix it because she failed to do it when she had the opportunity to do it. And saying I'm not introducing a deposition to do it, I'm doing it through a witness is no different. It's still under subsection 1, it still has the same requirements. The court's ruling is still proper. And you just look at the language of 5, and then you look at the case, you see that what she's been arguing to you doesn't address the actual issue. The case she cites talks about the defendant testifies to one thing, and they bring in multiple officers that testify to different facts. He had his cell phone. There was, a person over here instead of over there. That's not what they're doing. So, and again, although the court, Ms. Conlon is correct that the court can reconsider a ruling, the court has ruled. And I think it is, I do respect the defense's right to preserve a record, but the party should respect the court's rulings.
Talk to me, Mr. Wiggins, about materiality and Dr. Zadovich's statement. Would it not be material if there's a difference between him dying in 5 to 6 minutes versus him dying in a few hours? Would that be material?
It isn't. Materiality is not the issue. That's not what is going to should change the court's ruling. That may be.
Ms. Conlon is saying Section 5 of Rule 608 is applicable, and she's made the argument that the difference in how long it took for Mr. Redlick to die is material, and she explained why.
Yes, so we're.
And so what I wanted to know, just on that particular issue, assuming 5 is still legitimate, answer why is that not material?
Because we're misunderstanding what the language of 5. So what she is doing is introducing a statement to impeach the credibility. She's saying Dr. Zadovich said one thing on the stand, and she said another thing at another time. She's not, what she could do under 5 is call their own ME, their own expert. And if this was some issue that they thought was very significant to the defense, and there was the potential for either the doctor not to testify consistently, or they wanted to make sure they established these facts, they would call a witness and they would establish through evidence, because impeachment is an evidence. And that really should get to the heart of this. She is attempting to do an impeachment with a statement, and that goes to credibility, is not substantive evidence. This is the talk about you can offer evidence, material evidence, that also serves as a basis to undermine the witness's testimony. So she wants to call her own medical examiner and have that testimony. That would be proper under 5. But she is offering statements, not evidence. And so we're still under 1. Whether that statement is super important, it's still a statement, and it's not other evidence.
Let me read your cases, Ms. Conlon, and I will be back. to Detective Ware testifying regarding Jaden's statements about not hearing the father say, "You better have a good lie as to where you have been," the court is not going to allow Detective Ware to testify regarding that. As it relates to the medical examiner telling Detective Ware initially that it took the victim 5 to 6 minutes to die versus a couple of hours, a few hours to die, I will allow Detective Ware to testify regarding that statement made by the ME that he died 5 to 6 minutes after having been stabbed. So the witness can Detective Ware can testify as to the 5 to 6 minutes time of death versus a couple of hours for the time of death, but not testify as to the statement regarding "you better have a good lie as to where you've been." I am going to allow the defense to reopen their case. Mr. Wiggins?
Could I just speak to that point, Your Honor?
Yes.
We're about to call Detective Ware, so maybe just so they're reopening a case, they call her for that one point, and then then they rest, and then I call her again. We could just call her in our rebuttal and allow them to engage in that questioning and their cross-examination. It would have had the same purpose and effect and not do this sort of awkward situation.
Well, let's see. Defense, Ms. Conlon?
That's fine.
That's fine? Okay, well then I will allow you to ask your questions that way. Anything else I need to take up before we get started?
No, Your Honor.
Nothing from the state, Your Honor.
Okay, Ms. Redlick, I know you've been sitting here for about 45 minutes or so. Do you need a break?
I'm okay, Judge.
You're okay?
Yes,
All
thank
right
you.
then. So let's bring in the jury. But before I do that, did y'all look at the instructions? Mr. Parnell, I got your response. Ms. Garcia, you might be able to look at it while Mr. Wiggins is doing his rebuttal. Let's bring in the jury, please. Good morning. How is everyone? Good. Okay. Anyone watch the news last night about coverage for the case? Shaking heads no. Do any research? Visit any places involved? Everyone's shaking their heads no. All right. We will begin. Mr. Wiggins, Ms. Garcia.
The state calls Detective Pamela Ware to the stand.
Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Good morning, Detective Ware.
Good morning.
So during the course of your investigation, at any point in time, did you learn about divorce proceedings?
I did.
And who initiated the divorce proceedings?
Ms. Redlick.
Permission to approach, Your Honor?
Yes, ma'am.
Let the record reflect I'm showing opposing counsel with record identification states AI. I'm handing the witness's record identification as states AI. Do you recognize states AI?
I do.
And what is states AI?
It's a court paperwork for dissolution of marriage.
And is this the divorce proceedings that you became aware of during your investigation?
It is.
Your Honor, at this time, the state offers what's been marked for identification states AI into evidence. Any objection?
No objection.
AI will be admitted as the state's next numbered exhibit.
State Exhibit 64.
Permission to publish, Your Honor.
Yes, ma'am.
And number, let me see if I can books and journals. Under number 16, the durational alimony, can you read, starting right here where it says wife?
Wife is without funds with which to fully support herself without this assistance, considering the standard of living established during the marriage, as well as other factors set forth in applicable Florida statutes.
And then down here, on number 20, could you read this to the jury?
Exclusive use of marital home.
And then starting right here, can you start reading where it says wife?
Wife needs the exclusive use of this home and the contents thereof, both now and in the future, for herself and the minor children.
So moving to this page, can you tell the jury what was her employment status?
She was unemployed.
And then finally, can you read to the jury what the defendant listed as total assets?
It looks like $1,095,500.
Now, detective, during your investigation and the course of this investigation, and actually after the investigation was over, did you have an opportunity at any point in time in order to obtain and listen to some jail phone calls which the defendant made?
I did.
And I know that during your direct examination, there was in-depth conversation about you had multiple opportunities to speak with the defendant. Is that correct?
That's correct.
So you know what the defendant sounds like, right?
Yes.
Permission to approach? Showing counsel's mark of identification states G. Mark of identification states G. You recognize states G?
I do.
And how do you recognize states G?
My initials and a date is on top of it.
And on this USB, are there 2 jail phone calls?
Yes, there are.
And did you have an opportunity to review these jail phone calls prior to coming to court today?
I did.
And are these jail phone calls, is it the defendant's voice on those jail phone calls?
It is.
And you recognize that as the defendant's voice
I do.
on both of those phone calls, correct?
Yes, on both.
Now, Detective. And Your Honor, this time, I'm going to be asking to publish during this next set of questions what's been admitted as State 6. I'd like to go back to the search of the defendant's home. When the search was being done of the kitchen, were the drawers in the kitchen searched?
Yes, they were.
And were photographs taken and documented of anything of note and of value?
Yes, they were.
And when you were looking, you and the CSIs, when you're looking through the kitchen, were you looking for knives in those different drawers?
Yes, we were.
So first, let's talk about the drawers in the island, because there was the island where it had the flat cooking top. Did you open any of those drawers?
Some of them, but some of them couldn't be opened.
Some of them couldn't be opened,
No, they were decorative.
so they weren't real drawers.
Correct.
Now, let's move on to, you said that you were looking for knives in the kitchen, is that right?
Yes.
And if you found any knives, did you document the location of the knives in the drawers?
Yes.
And did you find knives in a drawer?
Yes, we did.
And did you find it in one drawer or multiple drawers?
It was one drawer.
Okay, so you looked in all the drawers and you found knives in one drawer, is that correct?
That's correct.
And it was documented with a photo, is that true?
Yes.
Connecting now. And Detective, is this the drawer that you located the knives in?
Yes, that's the drawer.
So this is the only drawer in the kitchen that had the knives, correct?
That's correct.
And for the record, this is photo 3528. And then looking at 3529, is that a close-up of that drawer?
Yes, it is.
One moment, Your Honor.
Detective. You attended the autopsy of Michael Redlick in this case, is that right?
That's correct.
And you spoke with Dr. Zadovich,
That's correct.
and she was the medical examiner who conducted the autopsy of Michael Redlick.
Yes, that's correct.
And you had a conversation with Dr. Zadovich, didn't you?
Yes.
And she told you that Michael Redlick bled out within 5 to 6 minutes. Is that correct?
That's what I understood.
That he died within 5 to 6 minutes of the stab wound. Is that correct?
That's what I understood.
May I have a moment?
Yes, ma'am.
Detective Ware, do you know the state of the Redlick's finances January 2019?
Yes. We, oh, go ahead.
And what was that based off of?
In the investigation, we had pulled some of the finances to see if they were.
Objection, Your Honor, hearsay, facts not in evidence.
May I respond? Detective Ware, you were shown the petition for divorce by the state, weren't you?
Yes,
And you mentioned what the assets were,
that's correct.
and that was back in 2018, is that right?
That's correct.
Thank you. No other questions.
Any questions? No, Your Honor. At this time, the state calls Annie Jones.
The whole truth and nothing but the truth.
Could you please state your name for the record again today?
Andrian Leonard Jones.
And the other day, we were talking about jail phone calls and some jail phone calls that the defendant made. I'd like to continue that conversation. So we mentioned that the defendant made some jail phone calls with a different PIN number. Is that correct?
Yes.
And could you remind the jury, and when you're looking for the different PIN number, how do you go about doing that?
Again, I start with the information given by the requester, law enforcement. I start with the PIN number of the inmate that they're requesting information on. I write down or I note the phone numbers that were called using that PIN number. Then I search the phone numbers, also having access to the inmate management system, the system that the jail uses. It says where a person is housed, how long they were there, knowing that I know which phones they have access to. It says from the time they were there to the time they leave. So then I know all of the calls that were made using that PIN in those dorms. Again, as I search those numbers, if I find calls made to the same number by a different PIN, I check those calls to verify who it is that's making the call, listening for the inmate to self-identify, say their name, answer to their name. As I find the calls made by the individual whose calls were requested, regardless of the PIN that was used, I include those in the information that I provide to law enforcement.
So the other day, one of the phone calls that we entered in was a phone call to the number of 440-502-9799.
Yes, ma'am.
Okay. And was that the number in which the defendant was calling to using these different PIN numbers?
Yes,
So the one call that we admitted the other day, she used her PIN number, is that correct?
it is.
And then she called that exact same phone number using somebody else's PIN number, right?
That is correct.
And the PIN number that was used, was it 19013783242?
Yes,
And did it belong to a Connie Kent?
it did.
Okay, and then did Connie Kent and the defendant, were they housed in the same unit?
They were.
And so the permission to approach, Your Honor? Showing counsel some mark identification as states G. Handing the witnesses with mark identification as states G. Do you recognize states G?
I do. This is call information by the inmate requested. When I listened to the calls on here, I verified the calls and I dated and initialed it AJ.
So these are the two, so these are the calls, there's two calls on here, is that correct?
That is correct.
And these are the two calls in which the defendant made to that number we were just talking to,
Yes,
and they were using that different PIN, is that correct?
that is correct.
And these calls, these are fair and accurate depictions of those calls?
They are.
And these calls are kept and maintained in the regular course of your business?
They are.
Your Honor, at this time, the state offers with mark for identification of states G into evidence. Any objection?
We'll renew our pretrial objection to this evidence.
Objection is overruled. G will be admitted as the next number to exhibit.
State Exhibit 65. Commissioner Culture.
Yes.
So let's talk about the first phone call. The first phone call, was that made on May 29th, 2019 at 9:18 PM?
That is correct.
Judge, may we approach before the publication?
Okay, ladies and gentlemen, I'm going to read to you an instruction on listening to a recording. Members of the jury, you are about to listen to a recording, two recordings. The court instructs you that the recordings have been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recordings have been edited should not concern you in any way and must not impact the way you listen to and consider the evidence.
So we're going to listen to, once again, that first phone call, May 29th, 2019 at 9:18 PM.
Yes, ma'am.
For English, press 4 select. Please enter your spot. Please enter the area code and phone number you were called. Please hold. Please wait while your call is being connected. Please hold. Hello, this is a prepaid call from. Mommy, this is Connie, your mama.
I'm going to pause it right there for just a second. So this is the prompt. We obviously didn't hear Danielle. Is that because it's that different PIN number?
Yes, the person said their name, Connie.
and Orange County Corrections. To accept this call, press 0. To refuse this call, hang up or press 1. To present calls from your current balance is $21.95. This call is from a corrections facility and is subject to monitoring and recording. Thank you for using Global Tellink. Hello?
Hey, please. Did that come through weird?
Yeah.
Well, don't worry about it. So can you talk for a minute?
Yeah.
Okay, right here.
Yeah.
From your own mouth.
No, I'm home.
How's it going? Nice. Visit?
Yeah, so far.
Yeah.
Back and forth, but.
Yeah. Did you see any of the video?
Yeah, a little bit of it.
Alright, well, I don't waste your time much. I wanted to kind of just like share with somebody stuff, for both tampering. They had another stupid charge there, tampering, because there was so much, I hate to say it, there was so much blood when I was trying to, anyway, without saying a lot. I was slipping on it, so I used a towel. They're saying, you know, that has to be tampering, so that's kind of BS, but, you know, it's like, could you consider, you know, whatever. So I don't know what happened between then and there. There's some evidence they keep getting, but I saw it, and it's just stuff they took out of the set, like we writing down stuff about when I was filing before, Michael was so angry, keeping a log of stuff, like, you know, he was just being addictive, like, oh, today Danielle did this, and it's like, all this stuff is asshole into me, you know, it's like, at one point he was such a perfect, oh, it was awful. The point is, I tried to get out of the divorce, he dodged a freaking, serve, you can serve somebody, you know, and, I tried to serve him 3 times, they couldn't get him, they finally, and I protected him at the end, he was at the house, you know, the last final serve. You know, I should have just wished God had gone through the divorce. What they're trying to do is get away, get evidence, or they're trying to make this a non-self-defense, because emotions were non-self-defense, which is horrible.
I read that, yeah, I read that.
I mean, this just, I'm dead in the water all the way around with all this stuff. He got so angry because I wanted to get out of the relationship, because I had finally had enough at, like, what, 5, 6 years ago? And then when I finally filed for divorce, it was, what was wrong with it? So, today I was so smashed by that, because they gave me 4 days of divorce, but I kind of sat on it, and I'm thinking, you know, I should have left. What I did take responsibility for was, I should have left. You know, I should have finalized the goddamn divorce, and for not leaving sooner that night, for not leaving sooner, period, that got so bad. Maybe, since his life is gone, I can take some kind of, you know, yeah, he's just Mr. Nice Guy, just Mr. Perfect, that just, the whole just went off the deep end. I'm not saying that I didn't have a freaking problems. I'm not saying that he didn't drive me. The last 6 years were awful. You know, I started declining. I tried to help him. I carried the brunt of the emotional shit on my shoulders the first 10 years when he started to deteriorate. Now he lost it. He had ED, he lost it. And you know what? Oh, the big freak ego he was, Mr. Successful. That's how he killed him. It killed him, like, emotionally. He started, like, resenting me and saying he didn't want me to leave, but at the same time he would treat me badly. And not in a loving manner, in a stupid, selfish, sophomore male way that he thought was, you know, I can go on. I tried to explain this to you guys back then. I don't know if it made sense, but long story short, it's like they're leaving me with this. Oh, I'm already degraded. I can't see my kids. They never talk about how they are out of school.
Oh, I talked to Teresa Malay yesterday, she probably had to call her back, but,
Well, my lawyer said something today about, somebody trying to do something for your guardianship.
I think she's working on it with them.
Or I could win. I don't think. And your testimony they would use, however, you gotta be
Well, she said,
honest with it.
did Matt come and see you at the board?
No, and I'm worried about that too. I don't know what he's up to. Because I know that my lawyer called him and was like, hey, back off. So I don't know if he wants to talk to me or if he's just like, you know, shooting shit, keep his little nut in his pocket from hand on shit. I don't know. He's washing his hands of it. I
Yeah, I'll call him tomorrow. Last time I talked to him, he updated me on everything, but so manager gonna come here, but I don't know.
Anyway, my friend is a center worker over there, and I was trying to find out who was over there, and I wanted a conversation with him. But,
I'll email him as soon as I know the them just to make sure if I know what's going on. Did you get your money?
it looks like there's money in there, yeah. Thank you. We need a shakedown after we need to. But,
So you're gonna just go to the store?
no, I'm gonna go order it now. I have time. I saw that there was money in there. I started looking at it. Yeah, thanks. I don't know what you had to do for that or if that helps, but.
Also, there's about something I ordered you, the one you asked for.
Oh, wow. Okay, that's perfect. I mean, I feel like a king now, but I have something in there. No, I need to wait my baby too. I've been praying on, no, for instance, maybe I'm praying for the wrong thing. This is a confidential call, and how we, I mean, as far as I know right now, don't ask me how, but whatever you say, I'm saying, you could, I need to know how to handle this, please. I'm trying to, I'm thinking about writing a letter and saying stuff, you know, like.
So not anymore.
That morning, the day I Googled how to split wrist, and that was up in the browser. But that was, I can't.
Yeah, I saw that in all the paperwork too. I saw all that in
But
the
it's not true, but
motion.
it's, I could able to, do my, let's try on the outside, I have a call with you like this, it'd be okay. We could talk better, I could rather focus your meeting, you know? What they did, they went out, they just did this, like, you know, bang out, untouchable, job. With me locked up.
So let's move on to the next call. The next call was on May 30th, 2019, starting at 10:58. Is that correct?
Yes, it is.
And that was that same phone number, that 440-502-9799?
Correct, yes.
So that same number that she had called with her regular PIN, she's now calling with this other PIN.
Correct, yes.
For select, please enter your 12-digit TID number. Please enter the area code and phone number. Please hold. Hello, this is a prepaid call from
Mommy, this is Connie, your mama.
an inmate at the Orange County Corrections. To accept this call, press 0. To refuse, your current balance is $16.34. This call is from a corrections facility and is subject to monitoring and recording. Thank you for using Global Tele. Hello?
You know, and like, and so we know, you can't hear this call. I could have called family members, I could have done, working my own, you can't work a case in here. None of it was, whatever. And I could have, like, when I talked to Taylor, Junior, I didn't say it right. I can't want you to, I talked to him, now he was saying, I'm just telling you, and as soon as I said that, I'm going to, okay, well, just, let's get this statement, statement. Yeah, that's not like I felt like I could have conversation with my son. I would say, look, you're going under oath, on our, like I said, that's you know what I mean? Like, and there's still other stuff that if we waited it out or if it's investigated more thoroughly, more questions were asked properly, or if it was, if Eric Parker was the first one to help me, I don't know if this looks like self-defense, you might have to reposition this. He knew that right beginning, and I told my lawyer. And my lawyer now is sitting with
I mean, it's like you either have to decide if you're gonna take this plea that they're telling you is good, or you take your chances with the jury and you could possibly get life, or, I mean, that's a lot to sit on, and I don't know. I know, but I just,
It was self-defense, and it was a struggle, and it was a shame. They'll see that it's not second degree murder. You don't murder someone that is armed. That was more of a.
I know, but I just.
It was self-defense, and it was a struggle. and it
Not
was-
this one.
I don't know if this looks like self-defense, you might have to reposition this. He knew that right from the beginning, and I told my lawyer. And my lawyer now is sitting with them, telling them, oh, it's not self-defense. I already told him this months ago.
I mean, it's like you either have to decide if you're gonna take this plea that they're telling you is good, or you take your chances with the jury and you could possibly get life, or, I mean, that's a lot to sit on, and I don't know. I know, but I just.
It was self-defense, and it was a struggle, and it was a shame.
No further questions of this witness, Your Honor.
Mr. Cornell?
Mr. Jones,
Yes, sir.
what time she's been in jail? Do you know how many calls she has made?
I don't know that number.
Nothing further, Judge.
No, Your Honor.
Thank you.
To the state, while the defendant may have the burden of going forward with evidence of self-defense, the burden of proving guilt never shifts from the state, and this standard broadly includes the requirement that the state prove that the defendant did not act in self-defense beyond a reasonable doubt. Also, there is no evidence that at the time of the incident that the act was committed with a depraved mind. Here, what we have is Danielle Redlick, who has taken the stand, and she has testified that this is a self-defense case. She has testified as to what transpired on January 10th, 2019. The text messages are in evidence. They corroborate the fact that Ms. Redlick had to leave the home, that Michael Redlick was getting violent, he was getting drunk, and so she had to leave the house. The text messages between her and Sawyer show that she had to have her son tell her when Michael Redlick was asleep and out and passed out, so that it was safe for her to actually sneak back into the house. On January 11th, this hostility still continued. You have Ms. Redlick's testimony that Michael still felt betrayed. You have voicemails that show that he was upset. There was also Jaden Redlick's, the extrinsic evidence that showed that on the day of the incident, Michael Redlick was still upset by this betrayal. He said to Danielle, you better have a good lie as to where you've been. that shows that he was still thinking about the betrayal that he discovered on January 10th, 2019. We also had testimony from Pete Diebel, who said that on the night in question, he was at a game with Michael Redlick and observed the demeanor of both Michael Redlick as well as Danielle Redlick. Michael Redlick was distracted, and what he wanted to do was to go home. Danielle Redlick was quieter than normal. So this is all consistent with self-defense. There's been no evidence set forth to disprove that on the night in question, Ms. Redlick did not use self-defense. So for those reasons, we would ask for a judgment of acquittal. I would also like to add that in Wiley v. State, 600 Southern 3rd, 588, Florida 5th DCA, it states that extreme reckless behavior itself is insufficient from which to infer any malice. Moreover, an impulsive overreaction to an attack or injury is in itself insufficient to prove ill will, hatred, spite, or evil intent, which is what you need for second-degree murder. As far as the tampering charge, we rely on our previously stated grounds.
Your Honor, I'd rely on my previously stated arguments. This case is for the jury to decide.
What about her arguments about the evidence being insufficient to rebut the self-defense argument?
Well, that's not a standard. It's just, is there competent substantial evidence to sustain a verdict? And there is. And if we want to go down that road, Ms. Redlick's every statement she made until this trial started that she didn't act in self-defense, standing alone, is enough to create an issue for the jury to resolve. Showing up in trial and telling it for the first time ain't enough.
All right. As to both counts 1 and 2, the court is going to deny the judgment of acquittal arguments. There is sufficient evidence for the jury that the state presented for the jury to find beyond a reasonable doubt that the defendant acted with a depraved mind. And there is sufficient evidence, sufficient evidence to rebut the self-defense argument. So yesterday we talked about jury instructions, and I sent to both of you the instructions that I worked on. Mr. Cornell said he didn't have any objections. Mr. Wiggins or Ms. Garcia, do you?
Your Honor, just for clarification, you just highlighted areas you wanted the parties to just pay attention to make sure that they were acceptable.
Right.
Okay.
And what my concerns were. Looking at page number 4, sometimes we say dwelling house, sometimes we just say residence. And I did not know if you had any preference on either one. I would prefer that they be consistent, that we always say dwelling house or residence.
Acceptable to the state, Your Honor.
To just say one or the other, or to say both?
Either is acceptable to the state. I'll defer to the defense in the court.
Which do you prefer? Do you want to say both, Mr. Parnell, or do you want to say one or the other?
I'm fine with both being in there.
And I'll leave that. I thought we had talked about this yesterday. Oh, no, here we go. You could look at page number 12. What I had highlighted here, I wanted to make sure that the fourth. So in the second paragraph, what I have highlighted is, or any attempt to commit manslaughter, aggravated battery, or aggravated assault upon or in any dwelling house in which she was present. Is that acceptable to the state?
Yes, Your Honor.
Defense?
Yes, Judge.
And then it's the same issue in this next paragraph. Manslaughter, aggravated battery, or aggravated assault. Any objection, state?
No, Your Honor.
Defense?
No objection.
On page number 13, I highlighted 776.013. I can take that out. Wanted to make sure that we understood that that particular section was for basically the castle doctrine. And so you want to keep that one in state.
Well, I'd like to remove the statute.
I did.
Okay. And we're pulling this language from the standard,
Yes, it is.
and was this something that was not in our agreed upon instructions yesterday?
It wasn't the agreed upon instructions yesterday, but I just wanted to make sure that
It's
you
acceptable.
recognize that it was from it's the castle doctrine.
It's acceptable to state, Your Honor.
And that's acceptable.
What?
To you, Mr. Parnell?
Yes, Judge.
We're presenting two theories of justifiable use of deadly force. One theory is the theory that applies to being within a dwelling home. The other one applies to being out in the world, everywhere else. Upon further consideration, I don't know why it makes sense to give both if one is applicable. Squarely on point. I believe defense had requested both, but now having slept on it and having co-counsel point it out, I think that it kind of makes this longer than it needs to be and maybe more confusing than it already is.
That's the reason I brought it up. Mr. Parnell, what are your opinions about that?
Not really sure why it would be confusing. It's an accurate statement of the law.
But that particular section is the castle doctrine.
Right, I think
Not really what we have here, but
I don't think the jury should be in any scenario where they don't understand the law about her having to retreat or having no duty to retreat. I think an accurate statement of what the law is should be here.
Well, if defense wants it, I'm certainly not going to argue to take it out, but I think it makes it maybe more confusing. But it's definitely defer to defense on this issue.
what do you want to suggest, Mr. Williams?
I was going to suggest allowing the jury to go to lunch, so we could maybe get back a little earlier if we let them go a little earlier.
Let's do that. So we'll start at 1 and then end, if I do 2 hours and 2 hours for your closings, then we'd end at 5.
Yes, sure.
All right, let's bring them in and I'll tell them that I'm going to let them go to lunch now. We'll come back at 1. I just wanted to bring you in to let you know we're going to go to lunch now, and so we'll come back at 1 o'clock. And when we come back at 1 o'clock, you will have the jury instructions in your chairs so that you can follow along with me while I'm reading. And after I give part of the instructions, then the attorneys will begin their closing arguments, and I will follow up with final instructions. And after I follow up with my final instructions, the alternate will be dismissed, and then the panel will go back and begin their deliberations. So 11:30 to 1 o'clock. I'll see you back at 1. Have a good lunch.
You ready, please?
I need you to say that after we. Is there anything, any issues on the verdict? State?
None from the state, Your Honor.
That's-
Verdict form is fine.
Okay, so, I will have these printed out. I will have a copy for all 3 of you at defense table and both of you there. I'll have one for you for reporter, the 8 there, and, everyone have a good lunch. All right, we are in recess until 1. Ms. Garcia.